welcome everyone. Today is for the COC Lean Coffee. My name is Judy Gordon. I am the VP of Marketing at OmniSparks. And today we're very excited to be joined by Carol Pegnato and Connor. So why don't we start, Carol and Connor, with you guys both introducing yourselves. And then we'll ask the people who are on the call to introduce themselves too.
Okay. Hello, everyone. I am Carol Pegnato, as Judy said. I am General Counsel for OmniSparks. I'm also General Counsel for a consulting firm that deals with disruptive technologies, including blockchain. I've been working in this area with OmniSparks for about a year now and have seen many of the legal issues come and go. And I look forward to talking to you all about it. Over to you, Connor.
All right, thank you. So I was a lawyer up in Toronto, and then I started consulting for blockchain projects, mostly connecting through Polychain. I then left private practice to work full-time at TrueBit, and was working very closely with Robbie and Sina, obviously, from Community Communities. And then while working with TrueBit, started working with Zeppelin on a project which I now lead called the Transaction Permission Layer. I also helped form the Blockchain Association, which is the leading industry association in space, which I can chat about more if anyone's interested. And now currently work with Hangar, which is a venture capital firm out of New York, which invests in highly regulated spaces. So I've worked a lot with projects that are looking to get their legals and operations off the ground in the space. So happy to chat in this conversation. Then if anyone has questions to ask for it, just feel free to.
Oh, great. So both Connor and Carol asked that we start with you guys, the community manager participants, and just if you could just kind of introduce yourselves, and then also let us know if you're if you have a token or not, if you've issued a token or not, and then maybe one or two things that you're hoping to get out of this Lean Coffee. That would be great. And Don, I see you just unmuted yourself. So do you want to start?
Yeah, sure. Hey everyone, my name is Don. I lead business here at QuantStamp. For anyone who doesn't know what QuantStamp is, we are creating a protocol to make sure people cannot hack smart contracts.
Okay, great. So do you guys have a token?
We do.
You do, and you've issued it?
Correct.
Okay. And then are there one or two things that you were hoping to get out of the Lean Coffee today?
For myself, to be closer or to create more communities within communities, specifically within the legal field, I do think it's somewhat of an island. So just to see familiar faces and to move beyond Telegram.
Oh, okay, great. Thanks. Linda?
I'm going to go together with Don. I'm Linda Selker. I'm VP of Legal, also here at QuantStamp, and I work together with Don. We have the token that he already mentioned, and I'm also looking to support the community of communities. So thanks.
Great, great. Derek, you want to go next?
Sure. I haven't shaved in about 2 weeks, so I'm not going to turn on my video. Derek Silva, head of community and developer relations at Bloom Protocol. We have issued a token. It's called BLT, just like the sandwich, and we hope people like it just as much. Not looking to get anything specific out of the call today. I just really wanted to hear the discussion. Maybe I'll come up with a question later. Certainly, as a U.S.-based organization, we have very different regulations and requirements to adhere to than one based in, let's say, Singapore or probably Canada as well, where I am. So yeah, just wanted to hear what's discussed, and hopefully I'll come up with a question later, and I'll be happy to probably write it in the chat.
Okay, awesome. All right, Cassidy, you want to go next?
Yeah. So I'm working on the token design at a project called Centrifuge, and I guess the next step in that is what are the legal questions around launching the token. So we want there to be a token, but haven't launched it yet. So that's why I started chatting about this actually with Connor before as well. And really just looking to see what the community has learned about legal things. What are the kind of themes that come up that we should be thinking about instead of reinventing the wheel? And of course, paying for a law firm once we figure out what questions we need to ask. But also wanting to know what are the questions we should be asking, what are other projects facing, what are those walls we're going to hit in the future.
Okay, great. Thanks. So the first thing Connor and Carol wanted us to cover is kind of, they're both sort of focused on the US, and I don't know if one of you wants to start, but just talk about why the US, why the focus on the US, and what makes the US, I think Derek kind of talked about it, tricky.
Definitely tricky. Connor, you want to start?
Sure. Yeah. So I mean, maybe I have a little bit of a different perspective because I'm obviously based in Toronto, but everyone I work with, like Hanger, Zeppelin, the Zeppelin's head office in Buenos Aires, they also have a U.S. branch. So we consider American regulation a lot, and that was the case with essentially every polychain project I spoke with, and pretty much every other project I've spoken with. And part, I can also flag that from why it's important to consider the U.S. even if you're not in your company isn't in the U.S. So one piece is that with respect to a lot of regulators outside of the U.S., when they come up with regulations, they often look to the SEC or CFTC or other comparable regulators because those regulators are quite a bit more, I mean, the U.S. is the biggest capital markets in the world, and their regulators are quite a bit more sophisticated typically, I hate to say this, than, for instance, Canadian regulators that just don't have the same size and scale. And so they look to their American counterpart to see what they're doing, and they'll often mimic or at least derive a lot of the same, or they'll take kind of the conclusions of the American counterpart and then apply them to their own regulations. So the US signals for a lot of other jurisdictions what's going to be important. You also have to consider the US because if your token is owned by an American citizen, you might have to deal with the SEC eventually. So just because your company isn't based in the US, it doesn't mean that you're outside of their jurisdiction.
Just to add to that, if you sell anything into the US, you are subject to the SEC regulations. So unless you have figured out a way to stay outside US and not sell to anybody who is resident, any company or any individual who's considered resident in the US, you have to comply with US law. The other reason we're talking about US law is because it's the only thing I'm familiar with. So, you know, we'll go with that. So I can't opine as to if you are located in jurisdictions outside the US, I can't really opine as to your regulators. Connor may know a little bit more about Canadian regulators, but that's one of the reasons we're going to talk about the US today. And one, I am a lawyer, so I do have to make one caveat, which is nothing we say in here is intended as actual legal advice to you. It's more of a general discussion. You do need to seek counsel with, you know, somebody who's located in your jurisdiction and is familiar with the issues you face.
Okay, thanks.
Lawyer disclaimer.
Yeah, thanks, Carol. Always important to throw in.
Yeah.
So this is a community of people on this call are from the Community of Community Manager channel. So Carol and Connor, as our community managers are communicating on social channels, what should they be aware of and what should they be thinking of as they publish marketing materials?
I'll start. Connor, you can add. The first thing really depends on where you are in the capital formation, capital raising situation, where you are in terms of a token. Under US law, if you're a publicly traded company, you obviously have very strict requirements about what you can and cannot say about your business, about your security, in this case, your token, about when you say it, to whom you say it, how you say it. There are blackout periods. None of that should apply to any of you because there is no such thing as a publicly issued token in the US at the present time. That may change, and hopefully soon. But what you need to think about is generally both within the capital formation period and just generally when you're talking about your business is how are you communicating? First and foremost, thou shalt not do any harm. You cannot make any misstatements of fact. You cannot omit to make a statement of fact that has material consequences on what you're talking about. That's first and foremost something you should always keep in mind. After that, you sort of have to look at where you are. If you are doing a token issuance at a particular time, there may be SEC regulations that tell you who you can talk to and how you can talk to them. For the most part, in the US, if you're doing a compliant offering, you're doing it under Regulation 506C to accredited investors, and you can say pretty much anything you want as long as it's true. If you are looking at other regulations, you might not be able to be talking generally about the issuance of your token, about the offering. The other thing is you should never talk about the valuation of your token or any other token, because then you run into, are you giving investment advice? And that is a whole nother set of regulations. Connor, you want to expand on any of that?
No, I think from my perspective, you've covered that all really effectively, and you're going to have a lot more knowledge on the American security side. I would say a good resource for people to look at when making determinations about this, or thinking about the ways in which they want to limit what they're communicating to their community in their Telegram channel or their Slack channel or otherwise, is to look to some of the orders, the SEC orders that have already been made. This isn't the most recent one. It's about maybe like 14 months old at this point, but the Munchie order went in some pretty good detail. It was a relatively early order against Munchie, which was I think that was the name of the project, which is issuing tokens related to like a restaurant app, something along those lines. But they did a lot of promotion of the value of their token. I think they promoted the idea that they would be that they would get their token in secondary markets quite quickly. A lot of this seems pretty obvious right now as the things that you shouldn't do, but useful to go back and look at what the SEC said about and sort of the specific things they've listed, so you have a better impression of what you're going to want to avoid. And even if what you're if what you're issuing isn't a security or whatever, it's good to try to conform to these practices as much as possible.
Okay, great, thanks. So let's get to Cassidy's question, which is about capital, what you two were talking about when it comes to capital formation. So let's talk about ICOs. Are there different, better, some interesting alternatives to ICOs? And really, what are the models that companies are using today to get funded?
I think you have to, I think the SEC in the past few months has signaled that it is serious about saying that most token issuances are going to be covered by the US securities laws, that it is very difficult to prove you have a utility token, that you need to comply with US securities laws, which means that a lot of token issuances that were not done are suspect at this point in the US. And the SEC has signaled that they are serious about what they're saying. They're not going to change their position unless they're forced to, and they're not going to be forced to until Congress tells them to do something. And that you need to therefore assume, unless you have a very specific set of circumstances, that you are subject to US securities laws. That being said, it is relatively easy to do a Regulation D offering to accredited investors. Doing an offering to retail investors, no one's quite figured out how to do that yet under SEC regulations, although we do believe that there are going to be some Regulation A+ offerings that will be approved in the next few months. Those are expensive, they are difficult, but it does get you access to the public markets. Connor, you want to take it over with the Taxonomy Act?
Yeah, for sure. And I think essentially further to Carol's point, there's nothing as of now. There's been talk about some progress that Congress is making, and we think that the most promising progress they've made is with respect to the Token Taxonomy Act. So that's something that the Blockchain Association helped form. We helped member of Congress Hinman host a roundtable in September, and there are about 100 different projects and exchanges and investors represented there that were effectively saying they were saying essentially the same thing, which is that they wanted clarity around what were securities tokens and what weren't securities tokens. So Davidson was he was obviously attending, and then 5 other members of Congress. They went back, took that, and then over the last few months, we've been working with them to draft a piece of legislation, which was proposed at the end of December in Congress, called the Token Taxonomy Act. And the Taxonomy Act, among other things, identifies when tokens should and shouldn't be considered securities. And it's really very much in its early stages. So it was just initially proposed. We're sure there'll be several iterations before it's passed. Hopefully it is passed. But as Carol was saying, it seems like Congress will have to signal for regulators before we see a lot of movement with respect to clarity around what is a security and what isn't a security. We're not that optimistic that the SEC would make a big leap on their own without that being flagged. So that's where we're currently at. And again, I guess in terms of trends for ICOs, or just in terms of capital raise generally, I agree again. Like the move for a lot of projects now is raising privately and taking a bit of a wait and see approach.
So Derek has a question. Can you see it in the chat? I'll read it out loud. Do you think there's a good chance that the current Canadian federal government will introduce changes to the, all right, maybe I'll get all these initials right, PCMLTFA this year, specifically around KYC processes in order to make KYC easier, less expensive, et cetera?
Interesting. Yeah, thanks for the question, Derek. I have to admit, though, that I actually work exclusively with American companies. So despite the fact that I'm currently in Toronto, I'm not really that familiar with Canadian regs around this. But I'll take a more in-depth look into that and get back to you on what I think.
That's cool. Thanks.
Okay, great. So just talking more about ICOs, we know that the US, there's this discussion about security and utility tokens. Connor and Carol, any sense as to what you're hearing from the US government and what they think is necessary to be deemed a utility?
I'm going to take a very conservative viewpoint, which Judy knows often causes problems with our management team. I don't think there is such a thing as a utility token under current US securities law. I think, the only things they've said is okay is Bitcoin and Ethereum, and many lawyers on the conservative side of this question said the Ethereum decision was actually wrong, and that it, under definition of the Howey test, it would be a security. So I don't think there's a lot of flexibility. I know that there are, there's the Brooklyn project. There are other projects that are trying to sort of give a path to people to become a utility token. I don't see that as being an easy path, because not only do you have to make sure you're never talking about markets and you're never talking about valuation. Initially, you need to really deal with the decentralization. And quite frankly, as much as we'd all like to be in decentralized organizations, the very fact that we're sitting here means we're not. So it's a very long, it's a long process to get decentralized enough to become something outside of the Howey test. And like I said, I don't see the SEC changing its position. They have gone after a couple of projects in the past few months that were not fraudulent and were in fact done sometime before this whole discussion started, and said, look, you're a security and we're going to go after you. So I don't see that as being a real discussion. I don't see there being a lot of room there. But that is the conservative position, and there are many people who disagree with me. I don't know what Connor thinks about it, but.
Yeah, I'd say, no, I appreciate that. And I guess what I would add to it, I mean, obviously I believe it's accurate too in terms of dealing with the SEC as a project. You can't go out with certainty that as a result of whatever level of decentralization you have, you think it'll be sufficient. You have to factor in the risk of dealing with the SEC and other regulators when you make that decision. But all of that said, like, we are optimistic that things like the Token Taxonomy Act will help push. I can say that there's at least an appetite for Congress, both like among the Dems and Republicans, for pro-innovation in space. At the roundtable, a theme that came back over and over again, which seemed to be relevant for every project in the room, but also for the members of Congress, was that if the United States wanted to stay at the forefront of this innovation, like they have the internet, they would need to start adjusting regulations to encourage projects to stay. And even if that wasn't, a clear set of requirements around what kind of tokens would and wouldn't be securities, it was at least a process for projects to approach the SEC. And if innovators are trying to legitimately, do something legitimate, and they're trying to test out this new technology, and they're trying to get in the United States, they shouldn't be discouraged or prohibited from doing so, or they shouldn't have, as a consequence of having done so, face fines or other sanctions. So we see that Token Taxonomy Act again as a first step, and I definitely encourage anyone who's interested to go take a look. It's relatively easy to read, especially the section as it relates to the difference between securities and non-securities tokens. And that's kind of the path that we'd like to head down. We also looked to Hinman's speech, which is obviously not a statement made by the SEC, but it does seem like something that had been prepared, is now posted on the SEC site. It wasn't a one-off statement by Hinman on a panel. It suggests, I think, that the SEC is interested in seeing how these networks work, and if there is a level of decentralization such that tokens are no longer considered securities. So I don't know how the next 1 to 2 years looks, but I'm hoping that in the relatively near future, there's a world where there's more clarity around what isn't sufficiently decentralized, and that token projects that have launched are given a level of certainty that what they're selling are no longer securities. But again, that's a bit of optimism, and we just have to stay aware of what's being put out.
So we've talked about public offerings, and Cassidy, I just want to check in and make sure, do you have any other questions on public offerings, or?
I guess, I don't know if this is part of this section of what you guys want to talk about, but one thing I was super curious about, you talked about what's common in, I guess, what's trending and what projects do. And I see that a lot of projects tend to do this like foundation, either in Switzerland or somewhere else. And my understanding was that perhaps that was mostly for tax reasons. But I'm also curious if I'm just missing something, if there's like a huge reason why everyone is doing the same thing.
Cassidy, I think that is, it depends on where your project is located. Initially, everybody went to the Swiss Foundation model because that's what Ethereum did, pretty much is the short answer. But when we talked about our setup, and we originally came in with our management team saying they wanted to follow that, they wanted to be a Swiss Foundation and have some sort of business entity, that it didn't make sense to us. It doesn't matter where you're located, it's where you're selling your tokens, so it doesn't take you outside the realm of securities laws. If you are a Swiss Foundation, or you are in Malta, or you are in Gibraltar, or you're in Singapore, if you're going to sell to a US person, you got to comply with US laws. There are tax reasons to locate yourself outside the US. We as a project made the decision that that wasn't our purpose. We didn't want to avoid US taxes. We believe in paying taxes. So we weren't trying to structure around tax, either avoidance or reduction, but there are some reasons to do that. The other reason people go to jurisdictions outside the US is because those jurisdictions have sold people on the idea that they're crypto friendly, that they are, they've got regulations, they've got, a sort of a community to deal with. I think the community aspect is important, but as far as the regulations go, again, the minute you start dealing outside of that specific community in Gibraltar or Malta or Singapore, you are dealing with other laws. So I think it's it's less of a crypto question as it is a business structure question. What makes sense for your business structure? Are you trying to be a for-profit? Are you trying to deal with community issues, and where that's important? OmniSparks is a PBC. It's a Delaware Public Benefit Corporation because we believe what we're doing is making the world a better place. and we want to make sure our stockholders know that our priority is to make the world a better place rather than just to return profits to them. But that was our personal decision. And you can do that through charitable foundations like Swiss Foundations as well. That's sort of a long way of saying it really is an individual question. I don't know if Connor has anything to add about jurisdictional law, but that's my view.
Yeah, I think that definitely agree with what Carol's saying. And I think that you have the opportunity too. I mean, if you're working in Singapore and you're testing out a product and you're able to limit that product just to distribution of, say, Singaporean citizens, and I don't know Singapore laws very well, but if they're truly crypto friendly and say any token could be be deemed a non-security and you can just distribute between Singaporean citizens, then maybe that allows you to test your network or decentralize the product to some extent. So there could be some functionality in that. It seemed to me too like some of the novel structures that we were seeing projects describe in their white papers around making a for-profit business. You do token sale and you allocate a certain amount of the tokens for a not-for-profit that runs the network. That ultimately they use their resources or the remaining 25% of tokens or whatever to pay for improvements to the network until the network just runs itself. So I think part of that was a model that some projects were thinking about, and they thought that a good execution strategy would be to build a not-for-profit, which was focused on doing that, and maybe that's also for tax benefits. So I'd highly recommend chatting with people at Ethereum or other projects. I think there are quite a few that have decided to spin out the foundation model and ask them why they did it. That's kind of a good hack in terms of, because obviously legal fees, and this is something we talked about a little bit too, but obviously legal fees can be absolutely enormous, especially when you're dealing with a bunch of different jurisdictions. So I think the first person to go to when you're interested in a subject is maybe a friend who's a lawyer and he's not going to charge you, but the next person might be a project that has already gone through what you've gone through and might be able to save you a big headache, and maybe forward some of the information that their lawyers forward them, and then put you in touch with the right lawyers that they trust and they've enjoyed working with, and help you to avoid ones that aren't necessarily that familiar with the space.
And there are definitely some of these projects are on the channel. So some of the ones that I've talked to in the past have done this, have split out the foundation from the project. So there's definitely resources on the channel you could reach out to. Okay, so we talked about structuring fundraising. What about how do I think about compensation? So token issuance to stakeholders, employees, any hints around that as people think about fundraising?
Again, specific to the US, because that's what I know, and that's where many projects exist. There is this weird intersection between the tax code and the SEC about employee compensation matters, and it is a very complicated area. Many people thought they could follow the path of early stage companies that have been doing since the dawn of venture capital era, of just doing stock options and calling them token options. That actually doesn't work because the IRS, Internal Revenue Service in the US, says that tokens are not securities, they are actually assets. So the stock option route, the things that the IRS had built in to allow you to issue stock options on a tax beneficial basis to your employees does not apply to token issuances. So there are a couple of ways to issue tokens to your US-based employees. Again, this is under US tax law. One is to actually is to have the token ready to go and sell that token to your employees or gift it. There would be a tax to them. It would be deemed compensation to the extent that whatever the employee got it for is less than the fair market value at the time. The problem there, of course, is many projects are pre-token issuance, or many projects aren't ready to issue the token, in which case, how do you get the token to them? And what some of our advisors have suggested is you actually create the token even though you don't issue it, even though you aren't going to issue it outside of your employees, and then you control it through having wallets that are restricted and things like that. That is one approach. To me, it's rather complicated if you are in a pre-token position, because we don't really know where ICOs are going, where token issuances are going in the future. And you don't really know if the token, and it has to be the same token that you're going to end up selling, that you're going to end up using on the market in order for it to work. So that's one way to look at it. The other way to look at it is something called a restricted token unit plan, which is similar to a restricted stock unit plan. And that would allow you to issue the right to receive a token on vesting events, on certain specified events. And then that is settled at some time later, which would be your token generation event. That is another way to go. In other words, to sum up, that's probably a lot of information in a short period of time. Structuring a compensation package through tokens involves tax lawyers, accountants, and employee benefits lawyers. It is complicated, it is difficult, and we haven't quite solved it even among our own team, despite the fact that we have very good accountants, lawyers, and employee benefits consultants. So it is a difficult question. It will cost money to solve that question, to some.
Yeah, I think the only, and that's great. And I think the only thing for me to add on to that at least is that I've seen a lot of projects who've put this idea of like token benefits plans, or even like rights to equity. They've really just delayed on making any distribution to employees, and they've delayed about thinking on it really critically. And in the meantime, the valuation of their project or the potential value of their token keeps scaling up. So when they do end up issuing it to employees, they're going to receive as compensation something that's worth quite a bit, as opposed to, you know, if they just figured it out 6 months earlier, they'd haven't be able to make a much better case for tax purposes that the token was just worth a very nominal amount. So a really important thing to keep in mind at the beginning of the project, if you can, because it could save you an incredible amount of money in tax down the line. And then there are a few valuators who will also be in, based on the processes that I've been in with valuators, will be in the process. And there is a valuator called Technos, which has done quite a bit of work in the space. And I believe they're still considered one of the best for purposes of valuating tokens.
Okay, great.
What is the name of that company again?
Technos. Teknos.
Okay.
Great.
That is critical. And yes, Connor is absolutely right. The sooner you do it, the lower the valuation, the less tax implications you have to your employees. That's one of the reasons the restricted token offering plan restricted token unit plan actually does work, even if you've already had some valuation, because you are deferring the tax issues until the point where you settle that unit. And so that kind of is a better approach for companies that are further down the line than doing a stock offering of some sort or token offering plan. But yes, the sooner you think about this, the better. But again, it's expensive. It's hard to think about. So good luck.
All right, we have one last question, and then I don't know if any of you guys out there have another question, but we're going to switch topics a little bit to open source. And Connor actually brought this up in our discussion, yes, when we were kind of preparing for the call. Connor, do you want to talk about what projects should consider as they look to open source code? What projects need to keep in mind?
Yeah, and I am unfortunately not an open source expert, but I can, from a business side, go pretty high level on it, which is to make sure that you consider the implications of open source when you're open sourcing your code. That you're open sourcing that code will be dictated by the open source license that you use. The really popular ones you'll see a lot of on GitHub will be MIT or I believe GPL. And they provide users of your code with different rights around the ways in which they can work with your code, which they can resell maybe parts of your code. So those are really important to consider, as that really for most projects is the biggest portion of their intellectual property is the code they develop. And appreciate too that the implications of putting it out in the world. So we've seen more and more projects that have been forked, which could be a great thing for the ecosystem potentially. But if you're the project that is being forked and you spend a lot of time developing the code, and you feel like you might not see any value out of it as a result of it having been forked, that could be obviously problematic for your system. Recently, Hydra forked 0x, and that there could be implications there for the value of the 0x project. And maybe as an ecosystem, we say, that's a great thing, but as the project, as maybe in this example, 0x, you want to be really aware of what you're doing when you open source your code.
Okay, great. Any other questions, Cassidy or Derek? Nope. Okay, thank you so much, Carol and Connor. We appreciate the time you took to talk to the community.
It was fun.
Have a great day, everybody.
Bye.
Thanks, guys.